Jeffrey's laid out quite an important landscape in relation to some of the rhetoric that there is regarding human rights and the way that it's perceived within this country today. And some of the words that stuck out to me when he said that it was a very severe and vicious assault on human rights. But this has been coming for some time now. I mean, especially since 7/7, when former Prime Minister Tony Blair said that the rules of the game have changed. And they have been changing dramatically again and again and again. Every single time the UK government comes up against the Human Rights Act in the courts, it often gets blocked, and they have to keep on changing the rules in order to accommodate the fact that they're not able to just get away with what they want in relation to these human rights issues. And the case of Abu Qatada is probably the best example of that they have constantly and consistently tried to change the law in order to try and get rid of this man. And so our next speaker, Saghir Hussain, is going to speak on the topic of secret courts and the erosion of due process, which I believe will be a perfect segue from Jeffrey's speech.
Thank you very much, Asim. And ladies and gentlemen, with your permission, if I may remain seated when I speak. I'm not as fit as Jeffrey, so I think I'll be much more comfortable speaking sitting down. Anyway, as we said, the first point here I think we need to address is that how did we end up here, where we have a civilized, mature democracy under severe attack for having a rule of law, for basically having fundamental basic human rights. And I know Asim mentioned the 7th of July, and we hear about at the time where they said the rules of games have to be changed, whatever that means. But I would argue that the initial attack in the terms of the balance between the state and the citizens, I think probably started after the end of the Cold War, where we no longer needed a sort of mirror to the Soviet Union say we're wonderfully free and you're a totalitarians, because we are now with the sole superpower, and therefore we really want to have our own agenda set. A lot of those agendas are to do with the foreign policy. Foreign policy is inconvenient because there are a lot of civilized people all over the world who believe in resistance or freedoms or rule of laws or standing up to dictators, whether they're Gaddafi, Mubarak, or anywhere else. But before the fall of the Berlin Wall, that language was easy. But afterwards, obviously, it became inconvenient. And what we had is a gradual, in my opinion, I'm sure other lawyers here will correct me if I'm wrong, but gradual increase in the state's powers. And one of them was obviously the issue of criminalizing particular organizations, prescribing organizations, for example. So if those organizations were speaking against countries or authorities which we were supporting in terms of foreign policy goals, therefore they were to be defined as terrorists. So I think that was one of the earliest part of the changes in our values. And it probably started, I think, a lot in the 1990s. It's important to say that, Asim. I say that because everybody seems to think that this whole thing is to do with 9/11 necessarily. And I think we need to look at, to go a bit further back and to see the balance between the state and the citizen. But of course, how we ended up to a situation where someone like Sir Geoffrey has to make a sort of a passionate plea, and the language he's able to use, or he needs to use, in order to sort of get people to think about it seriously, is the ideological attack, I say ideologically driven attack by a few individuals who may be, media moguls or ideologically driven think tanks. I have no hesitation in mentioning Rupert Murdoch, Henry Jackson Society, various Islamophobia industry who's obviously jumped on the bandwagon now because we have a 9/11, we have easy tabloid ability to turn hatred towards a particular people. So let's use these bogey figures in order to increase the powers of the state, so that whereas in the past, we couldn't really say it, but now we say it's for fear. It's the fear element. And obviously that works quite well. Most sensible people obviously wants to live in peace and security. They don't want their trains blown up, and they don't want their airplanes blown up. So when those kind of threats are used, you do see a lot of complicit citizens, Jeffrey, I'm afraid, where they allow those rules to be extended. So with that, you had what we call the piece-by-piece legislation, and particularly since 9/11. And I'll go through some of the pieces of legislation which have been used in order to what you call erode due process, erode the rule of law. And I'll define those. And I'd say that a lot of them were actually aimed, or I suppose hints were given, these are only for Muslims. And I would say that many of the parliamentarians who sort of whilst they're busy with their expenses, rubber-stamped all this, thought, well, it's not going to apply widely. And as we know, most people now recognize that those legislation cannot just be applicable to Muslims, they apply to the wider public. And because they apply to the wider public, we are now, fortunately, building a coalition where people from different walks of life, different religions, or different political views are suddenly recognizing that the state has been playing a real serious game here, where it has used the bogeyman to get more powers, and we are seeing some parallels for those who do read and those who will see beyond the headlines in Fox News or the Sun newspaper and the Daily Star, that there are parallels in history, how states become more and more totalitarian and the implications that has for the citizens. So I'll start first of all by defining due process. Well, I'll try at least anyway, but as I can see there's lots of lawyers here and law students, so I won't try to be too smart, I'll be very general because I know I'll be corrected. But for non-lawyers, if I may, it's essentially what it means is a fair trial. A fair trial as defined in Article 6 in the European Convention on Human Rights and Articles 9 and 14 in the International Covenant on Civil and Political Rights. These are basic values, as Sir Geoffrey said, that people from all walks of life, from all political persuasions, felt were essential after they went through the experience of Nazism and the Second World War. And I thought it was just basic value. There's no problem with that. There's no real ideological difference with all these sort of things. And that entailed making sure that people were allowed to have a fair trial. And fair trial, as you know, it means that evidence must not be obtained by torture, that the defendant must be shown the evidence they are charged with, must be given an opportunity to present their defense. They must be given a fair opportunity in order to process their case, and therefore whether a judge or a jury afterwards decide they're guilty or not. That's later. That's after what you call a due process. Unfortunately, we've had pieces of legislation which, in my opinion, and I'm happy to take questions afterwards if you want, if you disagree with that, but in my opinion have eroded that due process. And I'll go through a little list of those legislations which I said were ostensibly aimed at Muslims at the start, but as we all know, the law of unintended consequences, it gets a bit wider application, and the states gets found out. And the first one, of course, is the Extradition Act, 2003, which was passed without much debate or scrutiny whatsoever. And the background to the Extradition Act 2003 was that before that, you had to have a prima facie case, a basic case to show that the British citizen had done something wrong in another jurisdiction, for example, the United States, and therefore that case went through the courts here. The courts would authorize the extradition before the person was extradited to America. And what the 2003 Act did was that as long as in essence, what it said was that as long as the application form was filled in by the clerk at some court in Oklahoma or in Connecticut, as long as the application form was filled in properly, in other words, names and date of birth and addresses, etc., the English courts, the English judges no longer had any right, and correct me if I'm wrong here, Geoffrey, had no right whatsoever to challenge that. And of course, many lawyers have tried to find ways of trying to resist that. And there is a great deal of suspicion about the real agendas here, and lawyers have done great work in order to expose the unfairness of it all and use different arguments, and I'm sure David and Toby here later on will sort of expand on that, in order to make it difficult as possible for the Americans to ask for whoever they want. Nevertheless, has to be accepted that the European courts have now finally ruled that really, as long as the application form, the basic information is correct, we have no power to stop British citizens being extradited to the United States. And let's not beat about the bush. That legislation was so-called response to the problems of the war on terror. In other words, these Muslims who were being arrested here, but the courts were not finding them guilty. The level of proof required, the level of scrutiny required by the courts here and the juries was very high, and therefore was very inconvenient. And you may want to look at the Ricin case, for example, where there's a massive hoo-ha, those of you who can remember, about a massive plot all over the country, to the extent where information was passed to every GP surgery in the whole country, how to identify the Ricin plot and how dangerous it is. This whole, a cynic might say, this climate of fear that was generated, so everybody feels, oh my God, we are under constant threat here. But that was a lengthy trial at the Old Bailey, which ended up, in short, members of the jury writing a book saying how disgusted they were with the prosecution case. In other words, they saw right through what the prosecution was trying to do, because that case was used as a Security Council by Colin Powell to justify, or attempt to justify, his attack on Iraq. So these were the wider agendas upon which people, individuals who were living in Britain were being used in order to fulfill wider agendas. So of course the Extradition Act proved to be inconvenient, and we've had, in all the bad luck we've had, oh my God, I'll be very quick, I promise. All the bad luck we've had, we've built some sort of huge coalitions with non-Muslims and other, bankers, people from different other walks of life, who've seen that this is a much wider application. Asim, if I may just very quickly indulge me, I'll rush through very quickly. The other piece of legislation, for example, is the citizenship removal, which is brought in for Abu Hamza. There's been about 21 cases so far. 20 of those have been Muslims. And one of the things that we found now is that even if you're born here, it's the way the legislation is framed. If you're stateless, or if you're not found to be extremist, that's the only defense you have. And the way the legislation is framed, it only applies to Muslims, mainly applies to Muslims, or if you're a Russian spy, for example, who's gone back to Russia already. So that's why the way the legislation is be framed here, so that's going to be widened. And I think that's also, in a way, a sop to the anti-immigration lobby to say, look, we are doing something about these Muslims and these foreigners. There's the control orders. Control orders are basically removal of your liberties, removal of your freedom to walk around without actually going through the due process of a criminal process, which was the normal historical way where somebody's liberty was restricted. You got deportation orders, for example, where if you weren't conducive to the public good, however Theresa May or her predecessors or successors may wish to define it, based on what the tabloids may tell them, that you could be kicked out. And then, of course, there's asset freezing. Asset freezing individual or charities or organizations based on secret evidence, right, suddenly had no right to answer it. Their assets were all frozen. Now, all this is, I would say, is underpinned by what's happened, by being discussed is secret evidence. And that secret evidence, I say any regime from Stalin to Churchill to Margaret Thatcher to Tony Blair, whoever, any regime would love to show its full hand to its public because it seeks legitimacy. Therefore, the argument is the reason why they are using secret evidence, because they know that piece of evidence is either been obtained by torture or there's an element of corruption involved in that secret evidence. And this is why that due process, that rule law is being denied to one particular section of the community, one particular section of citizens in this country, to be later on rolled to the much wider community. And I'll finish off, as we say, is to be institutionalized under the new piece of legislation just come through, the Secret Justice Act. So ladies and gentlemen, that's the reality we're coming under. The Muslims were the bogeyman, but everybody's going to suffer. Thank you very much.
I will disagree with you if I can. As you invited someone to disagree with you in the fine tradition of the bar, I will disagree with you on one point. As an extradition prosecutor myself, and having dealt with at least one American case, just to clarify the point, it's not so much the Extradition Act 2003, which is problematic, although it is full of problems. It's the agreement that the UK has with the US, which is a problem. And it's an unequal agreement, because if the US requests the return of anyone to the US, they don't have to show a prima facie case. There are still additional challenges that can be made to the extradition. It's that they don't have to show evidence. Whereas if we request someone to be returned to this country, we would have to show our evidence. We would have to establish a prima facie case. And so I agree that it places severe restrictions on those individuals being returned to the US for trial. There are still a number of safeguards. They may be very well theoretical, but there are still a number of safeguards that can be challenged during the extradition process. But it is the removal of a prima facie case which causes the most concern. Yeah.